So yes, thanks very much for asking me to join this webinar. My name is Jeremy Coy. I'm a Senior Associate, as you can see, at Russell-Cooke. My contact details are below, phone, email, and social media. So do get in touch if after this webinar you have any questions about employment laws, to the extent we can help, or just Russell-Cooke generally, our employment law practice. Just a little bit about the firm before I start. We're a full-service law firm representing corporates and individuals on matters such as employment, real estate, family, crime, corporate, civil litigation, and private client predominantly. We're based in Putney, Kingston, and Holborn, and if it's not something I can advise on, I'm pretty sure there's someone at the firm who can, if it's not employment related. Within the employment team ourselves, we have 5 employment lawyers and 3 immigration lawyers. So we have employment and immigration as one department, but they're very different areas of law. I don't practice immigration law, and similarly our immigration lawyers don't do employment, but obviously you can tell there's an overlap, especially with Brexit. We've become very, very busy. So what are we going to cover today? Effectively, it's going to be 90% COVID related, but also the legal issues that have come out of COVID the last 2 or 3 years. And then at the end, something on pro rata holiday entitlement due to a case that came out in July, I think it was, which has had potentially far-reaching consequences. So in terms of COVID, you may think, well, that's so 2020 or so 2021, but it's important for a number of reasons. Firstly, as you probably appreciate, the extent to which it takes a long time to bring a claim in the employment tribunal. A lot of these claims, 4 cases I'm going to go through, started around the pandemic, and the wheels of justice, certainly in the employment tribunal, go quite slowly. So it's only over the last few months we've been getting judgment from the court, from the tribunals. The first thing I should say is they're all first-tier tribunals. What that means is, while their judgments are important and interesting in seeing the way judges are approaching this issue, they're not binding. Only judgments from the Appeal Tribunal, Court of Appeal, and Supreme Court, which we'll come on to at the end, are binding law. However, they're very useful in any respect. Secondly, they're useful because they cover a couple of areas of law that we haven't had much guidance on recently, such as on health and safety, things like working from home, as you'll see there, and long COVID. Because obviously, although COVID has subsided, thankfully, to a substantial extent, although it's not disappeared, as we know, tragically, long COVID is becoming quite common, and the extent to which is a disability we will cover, as well as what happens if someone refuses to be vaccinated and is dismissed. Now, it's also important because, not to be too sort of doom-mongering or pessimistic, but there are people who say there'll be other pandemics to come. So the law that's come out of this COVID pandemic might be useful if we have a similar lockdown or pandemic or vaccinations in the future. So the first part to start is, before going into some of the case law, is just for some of you it may be a refresher, or some of you maybe new, is just a discussion about disability in the workplace and what is a disability. The definition for employment law purposes isn't necessarily the same as other tests, for example, tests, as far as I know, for state benefits, or common perceptions. You may have common perceptions that disability is someone in a wheelchair, or someone who's terminally ill, or someone who walks with a walking aid. All of those most likely are disabilities, as we'll come on to, but the ones that I see, I would say 90% of the time, and you may as well, in HR, are mental disabilities. And by that I mean generally work-related stress, anxiety, depression, sometimes even PTSD, post-traumatic stress disorder. Physical impairments tend to be commonly accepted as being disabilities. There's very rarely a debate as to whether someone's disabled. I've had one case, which is still going through the tribunal, where we had to do a long impact statement and provide a lot of medical evidence when it was clear the employee had two physical disabilities, and the other side accepted that. But generally, it's where there's debate is where it has a mental aspect to it, or a predominantly mental aspect to it, and that can go for long COVID as well, as we'll see. But obviously, long COVID is a fairly novel condition. So there'll be a bit of technical law in this, certainly at the end. But the definition for the purposes of the Equality Act, for the purposes of discrimination, used to be called the Disability Discrimination Act, is a person has a disability if that person has a physical or mental impairment, and that impairment has a substantial and long-term adverse effect on his or her ability to carry out day-to-day activities. So we'll break down those, the last sort of line and a half of that shortly. Deemed disabilities, by that I mean disabilities where there's no debate of whether they are disabilities for purposes of discrimination, are things like cancer, HIV and AIDS, MS, blindness, severe disfigurement. There's never going to be any debate over whether there's disabilities, partly because they're covered in the legislation, but even if they weren't, if they were of that severity, then it would be quite obvious that they were disabilities. So what are normal day-to-day activities? They're pretty much as set out in the bullet point. They're things that one does commonly on a day-to-day basis. Household chores, getting dressed, reading and writing, can be concentrating, and that can be problematic for some people with disabilities where they might have a job where they need to concentrate. Walking, participating in social activities. Importantly, these don't need to need to cause an absence from work. You may have a problem and it may be very painful, uncomfortable, or impossible to get dressed without help, but if you can still come to work, then are you disabled? Well, yes, quite possibly. Just because it doesn't stop you getting to work or working does not mean you don't have a disability. The third one is activities are a bit niche and unusual, and things that you can't do won't normally be enough to be a day-to-day activity. I can't be a highly skilled musician for a number of reasons, but none of which are that I have a disability. Similarly, if you can't be a footballer or a sportsman or an actor, sounds stating the obvious, but if you have a minor, for example, for a musician, if you have a minor hand injury or finger condition that you can't play a violin or a cello, unlikely to mean you're disabled. Could be if there's other issues, but unlikely. Substantial doesn't have much clarity or elaboration in the case law or legislation. It means what it pretty much says in the dictionary, so more than minor or trivial. So it really has to be a day-to-day adverse effects on your ability to live your life, really. And it doesn't have to be your ability always to work, as I said. It can be just to go about your everyday life. Most importantly, and something that sometimes people forget, is the effects of any treatment need to be disregarded, except glasses or contact lenses, because then that would be slightly ridiculous. What that means in practice is, and where we again commonly see it, is if an employee is depressed or anxious or both, and they are on medication, it's irrelevant for the purpose of whether they have a disability, that their antidepressants or other medication or therapy is making them okay. You know, they can actually do day-to-day activities, they can get to work and be functional. One has to consider, what if they didn't have that medical treatment? What if they didn't have that medication? Would they be able to do this? And obviously most people are going to say, with some probably validation from their doctors or specialists, that if they weren't on medication or weren't on therapy, or to put it more simply, if there were physical issues and they weren't using a crutch or walking stick or even painkillers, what would their life be like? And if it has an adverse effect on their ability to do day-to-day activities, subject to the other points I'll come on to, they're most likely disabled. So what does long-term mean? That's a bit more clearly defined. It has to have either lasted for 12 months, be likely to last for 12 months, or could last the rest of the person's life. Obviously, the last point would be more if that person sadly is terminal or is very elderly and they might not live for another 12 months. So lasted for 12 months is simple. Likely to last for 12 months, that would depend on medical evidence. And a lot of conditions, again, such as depression, but can be physical conditions as well, and can be long COVID, may cease and they may reoccur. And if they're minor at first, but they could be substantial, could lead to being more substantial, then they could be covered by the definition. Before I come on to this first case of working from home, why is this important? Well, it's important for a lot of the reasons related to COVID and some of the cases we'll see, but it's also important because, as you may be aware, as an employee, if you've been working somewhere for less than 2 years and you're dismissed, then your rights are fairly limited to unfair dismissal. You cannot claim unfair dismissal within the first 2 years, so your rights are limited to wrongful dismissal if someone hasn't paid their notice, unlawful deduction if they're just not paid the money they're owed or the holiday they're owed, but then only other claims which are more valuable and more complicated if they have discrimination claims, whistleblowing claims, which is outside the scope of this webinar, but happy to chat through another time if necessary, and claims under effectively health and safety legislation, which we'll come on to. So discrimination is what one calls a day one right. You can't discriminate against someone because of their disability or because of their race or because of their gender or sexual orientation at any time in employment. So with employees, you need to be very careful when dismissing, when taking disciplinary action, or when there might be reasonable adjustments if they have a disability. So the first case that we're going to discuss is working from home. Now, obviously, that has become much more common over the last 2 or 3 years. I think everyone who's worked in an office, was working in office in March 2020, will have most likely worked from home. It was quite common before then. I myself worked from home on occasion, but it wasn't generally accepted unless most commonly for women or sometimes men with childcare responsibilities who needed to work from home the odd day of the week to look after their child, or there may have been other reasons. Is it a legal right? I'm going to give a few short answers and simple answers to the extent I can here. No, it's not. There isn't any statutory obligation or rights rather that says thou must be allowed to work from home. Obviously, employment law in the UK is not as prescriptive as that. But legal rights in employment law can emanate from statutory obligations or statute law, such as the Equality Act and Employment Rights Act. They can also emanate from a contract. Obviously, under your contract, you have a right to be paid, and have a right to holiday and pension and sick days. Now, this is what Mr. Leach argued in Countrywide Estates Limited. He was a property valuer, and he worked at a company where they had actually a lot of COVID measures in place, safety measures in place, such as hand sanitizers, mask wearing, social distancing. And he actually worked in the office because of his job as a property valuer, so you can't really do it from home without putting a lot of strain on other employees. But when January 2021 came, and you remember there was a big uptick in cases, and there was a winter lockdown, he said, I don't feel safe working in the office. I want to work from home. They said no. What usually happens, as you may be aware, Pamela is aware, in an HR context, is employee raises grievance, says, I want to work from home. Employer says no. Employee appeals the grievance, says, I really want to work from home, please can you reconsider? And the employer says no. So then, as we advise employers and employers in these situations, if the employee's got more than 2 years service, as Mr. Leach did, the main option open to him is constructive dismissal. So resigning and effectively feeling that he's been dismissed because the employer has breached a term of his contract. What was the term of contract or terms of contract they breached? Nothing specific. There wasn't anything in his contract that said, you know, clause 2.4, you must be able to work from home. We are seeing that now more often, but that wasn't in his contract. So it was these implied terms of contract which are unwritten, but have kind of developed over the years from case law, and that is a term of mutual trust and confidence. So employer and employee must have confidence in one another and trust each other, and a duty on behalf of the employer to provide a safe working environment. Now, in this case, the refusal to allow home working was not conduct that was regarded was not reasonable or proper cause. Given his job, given he had actually worked in the office before the lockdown, and given government guidance at the time said that you should work from home when you can, then there was no breach of a term of contract. Now that would be different. So he was not unfairly dismissed and he lost the case. That doesn't mean that an employee in a different setting could not have a potential case. And that could be where, for example, a solicitor or an HR consultant or an accountant make the same requests that Mr. Leach did, but for jobs where you don't really need to be out and about valuing properties and can feasibly do your job from home. So if you're a solicitor like myself, where you might not have face-to-face meetings anymore, or you don't go to court, if I had requested that, or a solicitor had requested that, and they failed to convince their employer, as Mr. Leach did, then I may have a potential claim. And so this does rest on its own facts. as a lot of case law does, but it's worth being aware of when considering sort of requests from working from home and so forth. The last bullet is be careful about discrimination and reason for dismissal. As I said, if you have a disability or you think you're being discriminated against on other grounds, doesn't matter how long you've worked there, someone might need to work from home, not in Mr. Leach's case, but where, as I indicated earlier, they have childcare responsibilities, they may have a disability, they may even want to work from home, for example, on a Friday for religious reasons, or if employers work on those days, a Sunday for religious reasons. Not the case here, but it's something to be aware of, especially if employees don't have 2-year service and they may feel that that's their only potential claim. The next case regarding raising concerns during COVID. Now, the Royston Veterinary Care Centre differed in a large, substantial way from countrywide estate agents, not because one was a vet and one was an estate agent, but because of the measures and the seriousness with which they took COVID. In this case, Miss Redina was, I believe, half Italian or had Italian citizenship as well as British. That's important because in March of 2020, you might remember that COVID started off very badly, firstly in Italy, in Europe, anyway, northern Italy. And so she was very aware of the concerns and was relaying these to this in a very polite, professional way to the practice manager of the Veterinary Centre Limited, and saying, you need to take this seriously. She was brushed off with, I think, excuses we've all heard over the last 2-3 years of, oh, well, it's just the cold, it's just a bad cold or just a cold, it will pass, the press are hyping it up, etc., etc. The practice manager still took this view after the Prime Minister in mid-March 2020 laid out the rules for lockdown and basically said you need to come to work as usual. Now, as you probably imagine, that's not in itself unreasonable. Vets can't work from home a lot of the time, in the same way as doctors can't, but even more so. But it wasn't so much that caused Ms. Redina to sue them. She was eventually dismissed because she raised these concerns over the health and safety and the lack of seriousness with which the surgery was taking COVID. And when she sued, she claimed for automatic unfair dismissal under Section 100 of the Employment Rights Act, 1996. What does that mean? That means that she claimed that she was dismissed unfairly for raising a reasonable health and safety concern. And that's important because if you've not been employed for more than 2 years, you do have the right to bring that claim. It's also important because you have uncapped compensation. You might be aware that in an ordinary unfair dismissal, as it's often called, the cap on compensation is your gross annual salary or the current limit, which I think is around about 91,000 at the moment. So it's a potentially valuable claim. And ultimately, she won, and the tribunal found that the employer's reasons for dismissing her were, I think in their words, extremely poor. They used fictional, unfounded reasons such as lateness and poor performance. And ultimately, those were seen to be not the true reasons. I mean, they weren't even legitimate. The true reasons for the dismissal, it was for her raising a concern. So this is similar to whistleblowing, effectively. It's the same sort of principle of employee puts their hand up, says this isn't right, I'm concerned over health and safety, or in whistleblowing you may be concerned about some breach of the law, and then they're dismissed because of that. And it's the because of part that's very important. I could raise concerns about health and safety, about whistleblowing to my employer, but if I'm made redundant for a completely different reason, because there's a redundancy situation, or for my performance or conduct, then that's not necessarily going to be a valid claim. You need to prove that you were dismissed because you raised the concerns. And they found that that was certainly the case with Ms. Rendina. So coming back to disability, is long COVID a disability? Now I do have to give a classic lawyer's answer and say it depends. And the reason it depends is because, and there has been law where, or a case where long COVID was found not to be a disability. I haven't used that case because it's not particularly important or interesting, because that case failed partly because they developed long COVID after they were dismissed. So you can't be dismissed for a disability if you develop the disability after you're dismissed, quite obviously. But it depends, because the symptoms of long COVID, as we all may well know, do really vary. and you will come back to that test of, do they have an adverse long-term effect on ability to carry out day-to-day activities? What is long COVID? I think in some definitions it's 4 weeks or more than 4 weeks of symptoms. Now, if the symptoms subside after 4 weeks, or they develop into fairly minor, trivial, I mean, trivial is maybe an insensitive word to use, but minor symptoms, then they're unlikely to be a disability, because they're unlikely to be either substantial, as we've seen, or long-term. But unfortunately, they can be longer. And in Mr. Burke's case, he had severe headaches and fatigue, which ultimately an employment tribunal found did qualify him for disability discrimination claims. He couldn't undertake things like cooking, ironing, and shopping, basic day-to-day activities. This case is also important because beyond COVID, the judge discarded the views of 2 occupational health reports that said he was fit to return to work, and crucially, that the disability provisions of the Equality Act 2010 were unlikely to apply. What does that mean? Well, that means that, and confirms really, that what an occupational health report says is not gospel in terms of whether someone's disabled. It can be helpful and it can be useful to an employer, but effectively, having a disability is a medico-legal, it's as much a legal question, and it's really only for a judge to form a view on. So occupational health reports have their place, and they're very helpful, and often employers do ask employees to see OC Health, but sometimes if they say there's no disability, where it's maybe a bit more complicated with things like long COVID, then employers may want to take separate legal advice and look behind the report just to cover themselves. Now, the last case the last case about COVID wanted to cover was an unfair dismissal related to the vaccination. Now, before I answer that question, which you'll see the answer to there very simply, why is this important? Because, well, this is unlikely to occur now, in the sense that most people have either had or have not had the vaccine, and this was very topical a year or so ago. Hence, as I said earlier, the wheels of justice moving very slowly, and it's now only recently have we seen the decisions. But again, it could come back to, or it could come back to be relevant if there is, heaven forbid, another pandemic, or employers start to ask for employees to take more evasive measures, such as being vaccinated. But to take a step back and just talk about unfair dismissal generally, can an employer dismiss someone for not being vaccinated? Yes, they can. Can an employer dismiss someone for any reason? Yes, they can. The way employment law works, as you're probably all aware, in the UK, is there isn't this sort of overseeing body or a court that will stop an employer dismissing someone. The only ways that can be done are if an employee has a claim for unfair dismissal, they can apply for what's called reinstatement or re-engagement. What that means is if they're ultimately successful at the tribunal, as we found, within sometimes a year or more, an employer can order that they are reinstated or re-engaged in a different part of the business. Now, that's rare for a number of reasons. It's often not awarded because the tribunal doesnn't find that it would be reasonable to do or appropriate to do that, where the relationship's often broken down. Obviously, often an employee doesn't want to go back, they just want some compensation. Often they'll have got a new job anyway, and they'll be advised to look for a new job in the meantime, unless they can survive financially in the interim. But in any case, they'd need to show that they've looked for a new role. The only other way an employer can be forced to keep employing someone is in very rare situations of where someone claims whistleblowing detriment, and they apply for what's called an injunction, which similar to an injunction where you stop the press reporting something or something like that. That's really rare. Whistleblowing is rare anyway. It needs to be done within 7 days of being dismissed, so you have to act very quickly and incur potentially substantial legal fees. And it's not always awarded anyway. You're not always successful. So when we're asked a lot of the time, can an employer do this? Can an employer do that? Without being sort of flippant, yes, they can. You can't stop them. But would they be facing a claim for unfair dismissal? If I was dismissed for tomorrow, and I've been here 5 years, for wearing a white shirt, I can't physically stop or legally stop Russell-Cooke dismissing me, but I could have a very strong claim for unfair dismissal. So this is what happened here in terms of the vaccination. Ms. Alette worked at Scarsdale nursing home, effectively. Now, I should pause there and say her case was brought, or she was dismissed for not being vaccinated before it became a statutory obligation on care homes for their employees to be to be vaccinated. And that was potentially important. But what the tribunal found in this case was that it was a reasonable management instruction, in the same way as it was a reasonable instruction to ask someone to come into work. They were a care home, obviously they had vulnerable patients, they had colleagues, but they also had, for commercial reasons, they had insurance. Their insurance premiums were affected by the amount of, or the fact that the need for the employees to be vaccinated. Now, a lot of people would say, well, this was a breach of my human rights. The tribunal said, yes, potentially. Article 8 of the European Convention on Human Rights, which still applies, nothing to do with Brexit, on the right to privacy applies, but that's not an absolute right. It can be interfered with effectively, or it can be qualified. And in this case, it was qualified in the sense that there was an overriding or an outbalance of the need to protect the public, protect vulnerable people from Ms. Alet's personal views on the safety of the vaccine. Now, just as with the case with working from home, just as with the case with long COVID being disability, all cases rest on their own facts. So query how different the judgment would have been if, again, Ms. Alet worked in an office environment where she'd worked from home safely for a number of months since COVID broke out, and she didn't want to be vaccinated for the same reason, that she didn't think it was safe. And she sort of said, well, okay, well, if you don't want me to spread COVID around, then why can't I work from home? Or why can't we take other less draconian measures than dismissal? And there may well be cases, to the extent they haven't settled privately, that cover this point, because it is potentially very interesting as whether an employer can dismiss someone when they make their own decision not to be vaccinated. The moral and scientific reasons of doing that aren't that relevant. It's, as we all know, we didn't legally have to be vaccinated. So where working in not working within around vulnerable people isn't triggered, then she may have had a different outcome. Haven't put it on the slides, but again, we come back to discrimination, and that was discussed quite a lot around the time of the vaccine. What if you had religious grounds for not wanting the vaccination? I think there was some talk of Muslim or Jewish sort of faiths not being compatible with it. I think that was found to be untrue, but some people may have believed it. Some people may have thought there might be some moral reason or philosophical reason not to get it that accords with their beliefs, for example, veganism, or just being anti-vaccinations generally. All quite interesting beliefs that people may believe gives them some protection if they're not vaccinated. Similarly, if they have a disability, where if they've had medical advice not to get the vaccine because it could affect their condition or the medication they're on. Also, there was discussion over pregnancy. You may remember that there was some doubt as to how safe it was for pregnant employees. And I think there was, to be fair, a lack of clarity from government and the health service about its safety. I don't think there was any evidence that it was unsafe, but obviously pregnant women were understandably worried about it. And that is important, because if they effectively are dismissed because they didn't get vaccinated for the sole reason that they were pregnant, then that could give rise to other claims of discrimination and potentially unfair dismissal. So these are just four of the quite a few cases, actually, at least a few dozen that have come out since COVID. It has raised a number of issues in the workplace, as I'm sure you're all aware, and everyone will know someone who's maybe had an issue at work, and things like working from home, disability discrimination, other maybe less common religious discrimination, pregnancy discrimination, are all impacted by this. And it'll be interesting to see any more cases that develop, and if any of these cases are appealed to the extent they haven't been already, because as I said earlier, to the extent there's a ruling by the Employment Appeal Tribunal or the Court of Appeal, then that would become good law and would be binding on tribunals. So I'm going to pause there, and so we'll move on from COVID, which you'll probably be all very glad to hear. But the bad news is we have some even more technical, quite mind-boggling law to just cover before I finish. So this regards holiday, and is holiday and holiday pay specifically now about as clear as mud. In fact, I think it's probably less clear than mud. So what this concern is not with holiday pay generally for full-time, regular part-time workers who will get holiday pay, and this isn't impacted by this decision. But this is a decision of the Supreme Court, and that's very important because as I've said, that's binding law. There's not a court above the Supreme Court, and so this will only be sort of be overruled by, or could be overruled by, a Supreme Court again, and we don't see that happening in the next few years. So what this effectively covered was Ms. Brazel was a music teacher at a school, and she wasn't a teacher where she was on a full-time permanent contract, salaried, as a lot of most teachers and employees are, school employees are, whereby they just pay the same every month, even if they don't work for a lot of the Easter and summer. Now, having been a governor at school, I still am a governor at school, I know that a lot of teachers still do work in the holidays, so it's not that they get paid for a month off in many occasions. But for her, she was more ad hoc, so she would teach music to students, different levels of work, of hours, basically. A few hours this week, less hours, a few hours the next week, and so on. This case, which seems so old now, but this is again the speed at which justice travels. This case started effectively in 2013, 2014, so it's been going on for about 7 years. When she was first working there until 2013, she was basically paid her holiday according to an average of what she earned over the last 12 years. So what does that mean? That means that, sorry, the last 12 weeks. So that means if she went on holiday and she had to take a holiday in the school holidays, if she took a holiday, then the school would look back at the last 12 weeks, find an average of what she earned, and then pay her that for her holiday. Now, what they then did, and if we'll pause there and say, it seems that if they continued doing that, we would not be having this conversation, and a lot of time and legal fees would not have been spent over the last 7 years. But they changed their tack, and in 2011, they followed ACAS guidance, as a lot of employers have done, and we had advised a lot of employers to do until this case, of a different formula. And what they did was basically pay her 12.07% of her average earnings over the last term. So if she went on holiday at Christmas, for example, they would look and pay her 12.7% of her earnings over that term. Why 12.7%? Well, because the way that's been worked out, or used to be worked out, is that there's 52 weeks in the year, there's 5.6 weeks annual leave as the entitlement, and therefore that leaves you with 46.4. And then 12.07% is effectively 5.6 divided by 46.4. And so there, that brings out how much that employee was being paid. She basically said, this is unfair. What you should have done is basically what you did previously, and looked back at the last 12 weeks and just paid me an average. All the courts, apart from the first tier tribunal, agreed with her. And that obviously shows us how important some of these previous cases are, and to the extent they might be appealed and the law may be different. They basically said, that's right. You shouldn't be using this 12.07% method, hence being crossed out there deliberately. That's not track changes. And even if that leads to a slightly ridiculous scenario, which it could do, as I'll come on to, then so what? That's what the law says. And the judges took quite a literal approach to the law and said, well, it's not for us to justify the fact that part-time workers may get better holiday than full-time workers. There's nothing in the law that prevents that. Part-time workers can't be treated differently to the detriment than full-time workers. Full-time workers can't be preferred, subject to some justification. But the opposite isn't necessarily the case. Part-time workers can be better off. So there was a lot of criticism of this, and a lot of kind of, heads in hands thinking, how can this be right? You can have a situation where, for example, this is an extreme situation, if you're an exam invigilator or a cricket sports coach and you work 1 year, 1 week out of the year, or more, just a few weeks out of the year, your holiday pay is basically calculated on the basis you work every week of every year, every week of the year, because your average will be working, 40 hours a week or whatever exam invigilators do at any one time. It's irrelevant that they may not have worked at all before the exam period timetable or after the exam timetable. So to give an easy maths example, because that definitely helps for someone like myself who isn't a mathematician, if someone is working 1 week and is earning £1,000, they get paid that £1,000 quite obviously, but they also get paid £5,600 because it's 5.6 weeks pay. which is slightly ridiculous because it would mean that they could have other jobs for other employers and get the same benefits. And it actually means their holiday pay is more than their 1 week's pay. Now, if that's the case, that's the case. And the Supreme Court accepted that could be an outcome of this, but said that that wasn't enough to change their decision. And ultimately, what I think is going to be helpful for us as HR advisors is, well, how do we deal with this? The law's not going to change. And who is this going to affect? Now, who it's going to affect is obviously in the education sector, as you can see here, but it's also going to affect seasonal workers, such as mentioned, sports coaches. I was speaking to a colleague earlier who said it affected maybe sort of quite literally the gig economy workers who work in venues that put on gigs and festivals in the summers, for example, and it's going to affect seasonal 0 hours workers. And the way that will affect them was because they might have contracts which are permanent, as one would say, or effectively indefinite, and that they just work every now and then. Now, when it comes to taking holiday, what an employer is going to have to do is look at their average earnings over the last year, but discount times they didn't work. And therefore that could be quite an expensive bill, basically. And how to sort of get around it necessarily or mitigate it is really going to have to do some sort of audit of what employers do to calculate holiday pay for those with irregular hours. And to be clear, it is, as I said, only employees with irregular hours, and how they get around that in the future. One way would be most likely to have fixed term contracts to say, we need you for these couple of weeks. You'll get paid X, you'll get the prorated equivalent of 2 weeks pay between 1st of November and 14th of November. And if you don't take your holiday, we'll just pay you out the balance. It'd be quite cheap. The problem with that is it doesn't help if people are already on indefinite contracts at the moment, and also that it's quite an administrative burden for HR, for payroll, for legal, to draw up a number of fixed term contracts and then give new fixed term contracts if they come back 2 weeks later, for example. The other issues that employers need to be aware of is, since this case, it may have opened the floodgates. So you may get employees who are aware of their rights now, who bring claims for unlawful deduction of wages and say they've been underpaid holiday. Now that could be potentially valuable. There's a thin, I would say it's fairly thin, silver lining that they have to bring a claim within 3 months. So if they were last paid holiday pay in July, they'll be out of time, and it's only for 2 years pay, but it's still quite a lot. And if you're a big organization with a lot of these type of workers, it's a lot. If you're a small organization with 1 or 2 workers, it still could be a lot because you have lesser resources than bigger companies. So it's a bit of a pickle, and a lot of the academic commentary around this has been pretty head scratching, but it's unlikely to change, and it's something certainly to be aware of if you work in those areas. But ultimately, as it says in the last bullet point, Supreme Court just said this could lead to rough justice. That was their words. Their words weren't exactly it's Parliament's problem, but it's pretty much what they said. And you often see in judgments from courts or tribunals of, well, it's not up to us as judges to make the law, that's up to Parliament. So I haven't seen too much come out of this yet. It's only been 3-4 months since the judgment, but it's certainly something to be aware of on holiday pay. So I hope you found that useful. Happy to take any questions that spring to mind about COVID or holiday pay or anything else employment law related. And I think we have, the chat function isn't working, but we have a Q&A box, or if you want to speak out, you can do. I'm going to have to stop recording now because if you are going to speak, we can't have that recorded, but I'll be online for however long you need to answer any questions. Okay.